So I don't think there can be a proffer because I don't know what the proffer is. I know that I have a lot of questions about things that that the court was not told about in the briefing and the affidavits. So the answer, respectfully, is no. It can't be done by proffer.
All right. And which witnesses are you intending to call today? And I understand you're saying you wish to just put on enough and focus on the key issues, but just if I were to grant, I'm just trying to understand the scope.
Well, I think Mr. Gray is the first witness. The second witness.
We may approach.
Yes. Parties to the bench, please.
Okay.
Thank you, counsel. In regards to the question of what witnesses do you anticipate calling?
Mr. Gray, I'm going to get his title wrong, but Mr. Christensen is an investigator with the county attorney's office. The prosecutor, who we believe is conflicted off, and their offspring.
Okay. All right. Any input from the state at this point? All right. I'm assuming the next portion that we need to address is your motion in regards to the hearing itself, the evidentiary hearing, whether it's closed or open. Correct?
Is the court looking over my shoulder at
I'm
media
looking
counsel?
No, at you.
Okay.
Sorry, there is someone behind you, but I was trying to look at you. That monitor's in the way, but I appreciate the clarification.
When the county attorneys informed us of this factual issue, and we told them that we thought that there was a disqualifying conflict, we had an agreement that we would file our motion privately, I think is the correct term,
Sure.
so that certain identities were protected. And that was at the request, and we've continued to accommodate that, and we have no problem with that. So we are not pushing for this hearing to be closed, but we totally understand why it's appropriate to do so. And it is, and Mr. McBride has verbalized this very well in conversations among counsel, the record is going to be very, very muddy if we can't have examinations that use names and identities. It's just going to be super, super awkward. And so that's why we are fine with the hearing being closed, which I think it's fair to say we view as an appropriate deference to the requests of the county attorneys.
All right. To the state.
Given the extreme publicity and the issues that surround this case, we would ask that this portion of the hearing be closed. We've had communications with counsel for the media. We believe that they agree to that after taking a balancing test of the public's right to know and the right to an open proceeding and the privacy interests at issue.
All right. One of my concerns that I have, and is there any other parties weighing in?
I think there may be, Your Honor, both by
Your Honor.
WebEx and here in person.
All right. Well,
Your Honor, this is Jeff Hunt. Can you hear me?
I sure can, Mr. Hunt. Thank you.
Your Honor, thank you for the accommodation and courtesy to allow us to appear remotely. With me is my colleague, David Ryman. We represent the Deseret News, KSL, KUTV, and other news media. We would like to speak briefly to the closure issue, if that's okay.
All right, I'll hear from you.
We did meet closure, and council has explained that they believe it would be impossible to conduct this hearing or even portions of it in open court without causing prejudice to the privacy and personal safety interests of the family member witness involved. They've told us they believe it would not be feasible or practicable to approach this on a witness-by-witness basis or an issue-by-issue basis, because they believe the names of the prosecutor and the family member would be used throughout the examination of witnesses. So we have no reason to doubt the statements and representations of counsel, and in reliance on those would not be objecting to closure of the evidentiary hearing on the disqualification and the referral issues unless the court has a different view and believes that we could parse this on a witness-by-witness or an issue-by-issue basis. That said, Your Honor, we understand that counsel for the state and the defendant have agreed to review a transcript of any evidentiary hearing and make limited and appropriate redactions so that a public version of the transcript could be released. And with that, there are just a couple other brief points I'd like to make. First, we think that this should be the rare exception to conducting these proceedings in open court. There's a strong constitutional presumption of open and public court proceedings, and of course, enormous public interest in this particular case. That openness and transparency is an institutional value that serves this court, the participants, and the public well. The facts and circumstances of this particular motion, given the fact that it concerns a family relationship of the prosecutor, makes it a very extraordinary and unique situation that we feel, given the representations made, can justify the closure. Although we do believe in most cases, just the fact that a motion implicates a witness will not be grounds for closure. Second, we just wanted to get on the record that we believe that release of a transcript is not an adequate substitute for the ability of the public and the press to attend and view the proceedings themselves. For this particular evidentiary hearing, that may be the only practical mechanism for the public to obtain some information about the case. But again, we would expect this would be the exception and not become a regular practice. And finally, Your Honor, it's our position that any oral argument on the disqualification motion or the referral motion should be conducted in a public hearing. As this hearing itself has shown, a lot can be done and argued without disclosing the names of family members or the witness at issue and jeopardizing those interests. Counsel can refrain from identifying the prosecutor or family member to protect the asserted privacy interests. And we have experienced counsel. They could be mindful of that issue during oral argument, and it's not unduly burdensome for them to take those steps, and any burden would be greatly outweighed by the public interest in learning more about the motion and having at least an open argument. So we do believe that the argument, and I understand the argument will be made at a later date, not today, but that should be done in open court. That's all I have, Your Honor.
Thank you, Mr. Hunt. Anything further from the parties?
Your Honor, as to the oral argument, it is our request that it be closed, and the reason why is that we're not perfect. Names slip. It's happened in trials. It's happened in arguments before, and I'm concerned at the risk that could have if one of the parties, one of the attorneys, were to slip and identify those who ought to be protected. With that said, a fallback position could be not live streaming the event and requiring any redaction should an inadvertent mention of a name be made.
Thank you. Counsel, one of my biggest concerns is I have to make findings of fact that are very specific. I can't redact my findings when I issue an order. And I will have to cite to the relevant facts. And quite honestly, the name of the prosecutor is a relevant fact. I can't simply glaze over that and make an assertion. It's important because it relates to various factors that you may address and which has been brought up in briefing. And so this court is hearing as it relates to, and I will take this motion witness by witness. I understand that there may be a witness that this is applicable to, and the court will entertain that, but because this court has to make findings and has to cite to the facts, I need to be able to do that. And since I'm going to do that anyway, which I will, I'd rather address it in an open court. And again, I will entertain any motions, witness by witness, that are going to be called and be respectful of that. But going to Mr. McBride's point, you both have that duty. It's in regards to how you present, and if you're talking about a name that needs to be protected, that's on you, on how you speak. I can't. It seems inappropriate to create a safeguard to prevent you from making a mistake on accidentally saying a name. That I don't believe that would be a proper reason to close the hearing just for that. And I understand the pressure, counsel. I know it's difficult, but I cannot accept that as a reason to close the entire proceedings for the evidentiary hearing portion. But again, as the witnesses are called, I will entertain the motion whether to close the hearing per witness, and we will address it as we go. Mr. Novak.
Yes, sir.
Yes, Your Honor.
With that, how would we like to proceed? Well, first, is there any clarification needed on this court's ruling as we're proceeding into the evidentiary hearing?
I just want to clarify. Are you going to entertain motions to close at the outset of every witness? Is that what I understand?
If the motion is made, yes.
Okay, thank you.
May we have a moment?
Yes. Oh, looks like I'm off. Would it be easier just to go into a brief recess? I don't want to make you feel rushed. You have obviously important conversations. So it's the court's intent to enter a brief recess to allow the parties sufficient time to discuss whatever you need to discuss.
No, I think I'm comfortable moving forward, making a proffer right now, and asking you to reconsider that motion. And the reason is because courts, the Supreme Court of Utah, appellate courts, refer to witnesses by their initials all the time. In our pleadings, we often refer to witnesses by their initials. In Supreme Court of the United States opinions, witnesses are referred to by their initials, and that's because there's a privacy interest. In this case, I don't think a privacy interest could be greater. This case has polarized the nation in many ways, and there have been death threats made against other witnesses. There have been death threats made. My understanding is there's been threats against counsel, our office has received threats. Doxing is a real thing, finding people online, harassing them online. With the technology that we have now, it's not that hard to find out just about every detail about a person through internet searches, paid subscriptions to programs that do background checks. And we are extremely concerned that we will have a person that does not need to be subject to death threats, to harassment, to doxing, to all of those things that can be avoided. We're very concerned that that will happen, and happen to this person for no other reason than this person's father is a prosecutor on the case. Your Honor, I think that there's a way around this, that we can avoid those threats to her, those risks to her, and I think it's by referring to substitute names like we have in the public pleading. So, Your Honor, I would just really ask you to please reconsider your opinion. There's a stipulation from the media to shut this portion of the hearing. There's stipulation from the defense. I think the court, in its ruling, can refer to the prosecutor as the prosecutor. I think it can refer to the child as adult child. I think that would be adequate. I think in a sealed record, there can be references to names. That would be my request, Your Honor. I can't ask more adamantly than I am now, Your Honor.
To defense.
We take no issue with anything that counsel has said. That's why we completely deferred to the the county attorney's initial request that all of the briefing, as much as possible, be under seal and then redacted.
Thank you. One of the points that when I was considering this as a potential issue is that both parties filed a public version of your motions, and you used a mechanism to convey that same information. And I understand that that makes it tricky, but it was the choice of the parties to do that, to publish those public versions. And the court is fine in regards to particular witnesses referring to those terms that were used in the motions, but this court does not agree that the entirety of the evidentiary hearing needs to be closed. And it is a very broad approach to a narrow issue. And I understand and I respect the concerns made by Mr. McBride, and I understand that, and the court is willing to go witness by witness. If you feel that a particular witness, that needs to be closed, the court will entertain that. I understand the issues of safety, and the court feels the urgency and the importance of that has been stated, but this court cannot find that the closure of the entirety of the evidentiary hearing is proper, given the motions that have been filed publicly online. And I have to leave it to counsel in deciding how you present the evidence, how you state the names. I'm willing to abide by the format used in those public motions, but this court denies the request to close the evidentiary hearing. And again, we'll take witness by witness a motion if that particular witness needs closure that particular witness's examination needs to be closed.
If the court's ready to begin the evidentiary hearing, we would call Jeffrey S. Gray as the first witness.
All right.
Or if the court wants to take a little break, we can do that too.
The courts can move forward. If parties need a break, I'm happy to give a break. I know we're switching gears here. Yeah, go ahead. In fact, let's go ahead and take a brief break. We need to relocate our court reporter, so this is a natural spot to take a break.
Can we have 1 moment of sidebar?
Absolutely. Hold on, counsel. All right, court is back in session. Counsel?
I believe the exclusionary rule is being invoked.
Yes, Your Honor, we'd ask the court to exclude all witnesses during the testimony of other witnesses.
All right, and to the state, any input?
We agree.
Okay. And at this time, would it be convenient to just take a brief recess?
Yes, please.
All right, it's 3:20. How about we come back at 3:30 and resume on the record?
Sounds good.
All right, court is in recess.